Hello friends, good afternoon. This is our usual program, our weekly program, Women Empowerment and Legal Aid. Our program where we discuss the rights of children and women in Nigeria. Today we'll be looking at the topic that you will be interested in, and that is custody of children and the family. In the event of divorce or separation, there's usually an issue that brings up problems, and there is the need for intervention, especially when there is a dispute, and that is intervention of the court in issues of where will the children stay upon dissolution of the marriage. Yes, of course, many times that the marriage is marriage under the act, or marriage or just marriage under the customary law, or cohabitation, whichever case it may be, whatever may have been the beginning of the union that produced these children will usually not matter in the decision of where will the children stay upon the solution of separation of the parties to the marriage. And I'm talking about the product of the marriage now. And in those days, the idea or the general practice or the general belief is that the children, the rightful place of the children is usually automatically the home of the father, because of the patrilineal society that we are found as serving. But I want to let you know that the law is not necessarily like that. Under the law will not automatically award the custody of the children to the father upon dissolution or separation of the marriage. I am saying gone are the days where the people will say the home of the father is the place of the children, or the place of the father is the home of the children. It is no longer the law. As a matter of fact, the home of the mother can also be, or the place of the mother can also be the home of the children. I am saying that under the law, both the father and the mother have custody, the equal right to custody of these children. The right the father has is no higher or bigger or greater than the right the mother has to custody of these children of the marriage. And so, upon dissolution or separation of the marriage, usually the Section 7 of Matrimonial Causes Act, which is a law that governs custody of children in Nigeria, will apply. And what does this Section 7 say? Section 7 talks about the interest of the child. In other words, the interest of the children or of the child, whichever the case may be, will be considered by the courts upon the solution and consideration for where the child or the children of the marriage will begin to live after the dissolution. I'm saying, in considering the custody of the children of the marriage, what the court will want to look at is the best interest of the children or the child of the marriage. I'm saying of the product of the marriage. And therefore, we talk about the interest. Now, when we say the interest of the children of the marriage, what do we mean? So when we talk about the interest of the children of the marriage, we are talking, number one, about the education, the environment. Yes, the court will want to find out the environment, the good environment that the child should be, the education of the child, who amongst the two parties can provide a better opportunity for good education, for good upbringing, for good religion, for good morale, who amongst the two parties, I'm saying the two parties now, the mother or the father, has a better facility to take care of the children of the marriage. If it is the mother that has a better facility, of course, the court will go ahead to award the custody of the children to the mother, not necessarily to the father because he is the father of the children. No. The court will look at who can take the children better, who can take care of the children better than the other person. Who is the party among the two that has the better facilities, better psychological upbringing that can bring them up psychologically, emotionally, financially, physically. Who among the two can give them a better opportunity? And so we will therefore look at, number one, the earnings of the two, of the parties. Who amongst them can afford financially to take care of these children? Who amongst the two of them will have a good environment? When I talk about good environment, I'm talking about accommodation and, of course, the environment where the party lives is very, very important, because the court will want to look at an environment that can give a proper development to the child, that will make the child to become a reasonable adult and a responsible adult in future, because the environment of a child contributes to the development of a child. Yes, of course, heredity sets the limit, but environment will bring it up or her up. And so the court will want to look at the environment, the court will want to look at the earnings, and the court will want to look at the conduct. Who amongst the two of them is more responsible? If a father has been irresponsible in the course of the cohabitation, in the course of the marriage, and just because he's a father, now he wants to ask for custody. Now the court will not allow him to have custody, because an irresponsible father during the marriage, during the course of the marriage, will continue to be an irresponsible father even after dissolution of the marriage. Yes, the court will also want to consider the age. This is very important. Yes, the age. Usually it is the practice, and the court will want to lean to the side of awarding the custody of young children to the mother, because it is assumed that it is the mother that can take care of the children at a very tender age. So a child that is below 7, from 0 to 7, will automatically, the court will want to award the custody of that child or those children to the mother, except while the mother is visibly irresponsible. I'm saying except the court can see that the conduct of the mother in the course of the marriage, during the marriage, in the course of the marriage, the conduct of the mother has been so irresponsible that the court cannot trust that the woman will take good care of those children. Of course, we also consider the sex. Yes, the court will want to lean towards awarding the custody of a female child to the mother, and of course a male child to the father. It will be very irregular for a court to award the custody of a female little child to a man, because as the girl grows, she needs some education about the physical changes in her body that only the mother can afford to teach her. Again, the court will want to consider who among the two parties can give a better educational facilities. Yes, this is very important. The court will be interested in the education of the child, because this is what will also contribute to the development of the child that will make him or her to become a responsible adult in future. So who amongst them can afford to give better educational facilities? But in most situations, the mother may not be financially capable, but if she is physically capable, the court will award the custody to her, and of course compel the father to pay the school fees. Why? Because it is the duty, and I keep saying it, it is the duty under the law. And as a matter of fact, as created by God, it is the duty of the man to take care of the family. Yes, and that is why the Bible says God put the man in the garden and said, tend the garden, which means take care of the garden. And the garden is the family, yes. So it is the duty of you, man there, listening to me. It is your duty to take care of those children as well as your wife. But upon dissolution, you may say the woman is no longer your wife, but it is your responsibility and your duty to take care of the child. Education, of course, you must be responsible for the education of the child and the maintenance of the child or the children, what as the case may be. And so the court will award the physical custody to the mother, and of course ask the parent, the father, to continue to provide a maintenance allowance every month or every year, whichever the case may be, whichever one is more feasible, and also to be responsible for the school fees of the child. Yes, and I also know that the court will also want to find out who amongst the parents is the child has affinity for. In other words, the child, especially if the child is old enough to decide, to speak, and to also tell the court who or she, who amongst the two of them she prefers or he prefers. Yes, the court will now call the child privately or the children privately and ask them, who do you want to stay with? Yes, the court will sometimes give the children that privilege where it is their right to decide where they want to live, especially when they are already old enough to decide who can take care of them better than the other. And so the court is okay, who do you want to stay with? Privately. Because if the court asks them in presence of the parents, they may be influenced or be intimidated. So the court will call the children privately while both parents are not there and ask them, who do you want to stay with? Where they will give their preference and the court will award custody to that parent. But I want us to remember today that both the mother and the father have equal right to custody, equal right to custody of your children upon dissolution or upon separation in the marriage. So don't let your husband deceive you or intimidate you to believing that it is the right of the father to have the child or the children of the marriage. It is not correct. It is the right of both the father and the mother to have custody. The woman has equal rights as the man to the custody of the children. Yes, the children may be answering in his name, but he or she, the child, also belongs to both of them. And so both the father and the mother have equal rights to custody. And depending on the circumstances surrounding their marriage, the court will decide who should have custody. Now talking about custody now, there are different types of custody. We can say, okay, there is what we call divided custody. Divided custody means that the father, the court will grant the custody to a parent, either the father or the mother, for a particular period of the year. Maybe for 6 months of the year, you will be with your father, and when you are with the father will be responsible for feeding, for everything, completely about the children. And the rest 5-6 months again, you will leave the father and go to the mother. And while you are with the mother will also have complete custody and will also be responsible. Well, it is believed that this is usually not made because it moves the children up and down. And that is what we call divided custody. Then we also have what we call split custody. Yes, split custody, the man or the father and the mother will be together. The children will be with the father with the consent of the mother, or the children may be with the mother with the consent of the father. But at that time, it decides solely. The woman decides solely where they live, which may be with her, but issues about maintenance or any other thing will be shared by both the father and the mother. What I'm saying is that when we talk about split custody, it does not matter where the children are staying. Either they are staying with the father or the mother, both parties will be responsible for the maintenance, education, and everything. This is what we call split custody. Now we come to what we call joint custody, and this is the one that is very, very popular. Yes, and it's very common. Joint custody is that the children will be living with one of the parents, but the other parent will have access to the children. Why they are living with either the father or the mother, and the other party will have access to the children, but during this period, the other party will also have a say, input in the decisions as to what type of school, where do they spend holidays, or any other thing, decision they may want to make. As a matter of fact, it is usually the practice that the court will award the custody to the mother or the father and ask them to spend holidays with the other party, other parent. So if the children are living with the mother during the school period, during holidays they move to the father, and vice versa. But within this period, everything about the children will be decided jointly by the father, by both the father and the mother. In other words, you cannot change the school of my daughter without letting me know, or the school of my son without letting me know as a mother, because both of us must have input in the decisions that concerns the children of this marriage. And that is what we call joint custody. Of a fact, there is again the one that is not very common, that is custody by a third party. And that is in a situation where both parties are incapable, either as a result of mental incapacity, financial incapacity, or any form of incapacity. Something must have incapacitated the two of them, such that neither of them can take care of the children. Yes, the court will usually award the custody to a third party. It could be a relation, and it could also be an outsider, a third party that is interested in fostering the child, not necessarily adopting the child, but just fostering the child. Yes, it could also be an official from the Ministry of Welfare, that is the Ministry of Youth and Social Welfare. Yes, any of these types of custody will be legal under the law. But the one that is very common, and I think the one that is more acceptable by parents, is the joint custody. Wherever the children or the child may be living, both parties will have access to the children. As a matter of fact, not just access, they also have input in the decisions that concerns them. I.e., where do they live, what do they wear, type of school they go to, everything concerning the children will jointly be decided by the two parents. Yes, I want to also remind you that the best type of upbringing for your children is that both the father and the mother will live together to jointly have a good, well-brought up child, or good, well brought up children. That is the best that is good for the children. Usually there will always be a bad effect of the broken home upon the children. The children are usually at the receiving end, and that is why I want to implore you that make that marriage work. But in the situation and in a condition that you discover that your marriage is not working and you are separating or you are divorcing, please remember that you have the right to custody of your children. It is not the right of the father to have the custody of the children, or the right of the mother to have the custody of the children alone. Both parties have equal rights to the custody. In case you have been denied access to your children, or you have been denied custody of your children because you think, or you didn't know you have this right and nobody to assist you, please, you can walk up to our office, Women Empowerment and Legal Aid. it is our duty to protect your rights. Oh yes, our office is at number 25 Adekunle Fajuyiwe GRA Ikeja. Today we have just told you the rights you possess under the laws to the custody of the children of the marriage. Yes, your children God has given unto you, and you have the right to have custody and access to them. If you have been deprived access to your children, or you have been deprived custody and to those children of your marriage because of dissolution, or you had a divorce, a dissolution or separation, please do not keep quiet, speak out. This program is Your Right, Our View. Until next week, I want to wish you a wonderful day at work, and I say women's rights are human rights. Thank you.